Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Let's turn briefly to privacy laws in general and electronic interception. There are some issues in privacy law that are agreed internationally. They are widely accepted by states around the world. The first is that privacy is a human right. In terms of how far that privacy extends, there seems to be widespread agreement that privacy includes privacy in electronic communications. As recently as 30 to 50 years ago, that wasn't the case, but is now widely accepted. What is also widely accepted, and I find that practitioners don't always appreciate this, is that the right to privacy is conditional, not absolute. There are a number of significant issues where there is a lack of agreement among and between states about privacy. First, with respect to scope. Where, when, and how do you have an expectation of privacy? Secondly, what conditions justify an invasion of the privacy you would normally expect? The right to privacy is conditional, so what are the conditions that justify an invasion? Third, what process is used to decide when and how those conditions are fulfilled? Will it be a judicial process, an executive process, formal, informal, levels of review? No international agreement on that. Finally, what differences in privacy rights apply if we're talking about intrusions undertaken by the state as opposed to intrusions by non-state actors? If we do look specifically at the topic of state interception or lawful access, what we find is that legal systems around the world are highly heterogeneous, and there's not a lot of agreement on how they should be structured. That makes them very difficult to compare with one another, and it makes it very difficult to try to abstract out generally applicable principles. Now, by contrast, there is some international agreement on technical standards. States will follow their own laws governing interception, governing lawful access. And the U.S. is especially complicated on this point because you have U.S. federal law, which talks about lawful access, as well as state law that deals with lawful access, and the number of statutes, the number of different laws that apply in the U.S. is blindingly complex. When we look at these various types of laws that deal with lawful access, there are some things that seem to be commonplace. So, for example, service providers are typically required to invest in facilities that will aid lawful access and to provide some degree of technical assistance when the state comes knocking and demands lawful access. Different states impose varying degrees of secrecy about the lawful access process. And you can see this in transparency reports by multinational telecommunications service providers, where they try to disclose how many interception requests they get in a given year from a given state. And some places they're able to give a lot of detail about how many they receive. And in some places they just note, we're not allowed to say anything in the state X or state Y about what types of lawful access requests we get from those locations. What is universally secret with lawful access requests is the question of whose line are we tapping, whose email are we reading, who, in other words, is the target of the interception investigation. When we look to interception undertaken by non-state actors, again, we find that legal systems are heterogeneous. They differ from place to place. And in this case, the restrictions might vary significantly based on the relationship between the person doing the intercepting and the target. If a person is running a public telecommunications service, then it's normally the case that they are prohibited from intercepting message content that's being carried over their service network. At the same time, people who operate so-called private systems, local area networks, things of that nature, especially when they're employers, are often given some flexibility to intercept traffic, subject to a variety of legal rules. That leads us into data protection.